Today, we're diving into a landmark Supreme Court ruling, one that really clarifies the rulebook for state governors. It all boils down to a pretty simple question, but one with huge consequences.
So imagine this. A state legislature works hard, passes a law, sends it to the governor. And then nothing. It just sits there. This isn't some hypothetical classroom question. It's been a real point of friction in our government. So what are the actual rules here? Well, the Supreme Court just gave us the official playbook. So here's how we're going to break it all down. First, why the president had to send a kind of SOS to the court. Then we'll get into the governor's actual playbook. We'll look at the idea of a constitutional conversation, the difference between discretion and direction, the big question about deadlines, and finally, what the court's ultimate opinion really tells us. All right, so why did this even end up at the Supreme Court? Well, because these constant standoffs between states and their governors were creating a ton of constitutional confusion. Things got to a point where the president of India basically said, okay, we need a final answer on this, and sent out that constitutional SOS. Now, the way this was done is through something called a presidential reference. It's a pretty special tool found in Article 143 of the Constitution. It basically lets the president go directly to the Supreme Court on a major legal question and say, hey, we need you to weigh in and clear the air on this for everyone. And this wasn't just a vague request. The president laid out 14 specific questions. You heard that right, 14. And they all pointed to one thing. Let's get crystal clear on what a governor can and can't do when a bill hits their desk. The goal was to write a definitive rulebook. And that brings us right to the heart of it all. The court's detailed explanation of the governor's playbook, which is all spelled out in Article 200 of the Constitution. You can think of Article 200 as the main instruction manual here. It's the part of the Constitution that lays out the whole procedure, what a governor's options are, and how they're supposed to use them. Now, this is probably the biggest takeaway from the whole ruling. For a long time, there was this argument that a governor had 4 options, including a kind of pocket veto, the power to just withhold a bill and let it die. Well, the court has shut that down, emphatically. They've said, nope, that 4th option, that pocket veto, it doesn't exist for a governor. So what are the real options? The court made it incredibly clear. There are only 3. Option 1, give assent. Simple. The bill becomes law. Option 2, reserve the bill for the president to decide on. And option 3, withhold assent. But, and this is the crucial part, they must send the bill back to the legislature with a message explaining why. And you know, this gets at the deeper philosophy of what the court is saying. They're not just outlining a set of rules. They're describing a process, one that's meant to be a dialogue, not a dead end. Right. So the key finding here is that withholding assent isn't the end of the story. It's not a veto button. It's actually the start of a conversation. The governor can't just kill a bill in silence. If they withhold assent, they are constitutionally bound to send it back and explain why. And you can really feel the weight of this idea in the court's own words. This quote from the judgment says it all, doesn't it? The entire system is built for this back and forth, for balance, for conversation, not for one person to just obstruct the whole process. And here's the final move in that conversation. If the legislature gets the bill back, reconsiders it, and passes it a second time, with or without changes, the game changes. At that point, the will of the elected body is final. The governor is constitutionally required to give their assent. The dialogue is over. Okay, so this all brings up another really critical question. When a governor is making one of these 3 choices, are they acting on their own judgment, or are they supposed to just follow the advice of the state's elected government? Let me put it another way. When it comes to bills, does the governor have their own discretion, or are they essentially acting on the instructions of the chief minister and their cabinet? And the court's answer on this was a very clear no. They confirmed that under Article 200, this is one of those specific areas where the Constitution gives the governor discretionary power. They can use their own judgment, separate from the advice of the Council of Ministers. All right, let's talk about the very practical problem that kind of kicked this whole thing off. Delays. Just endless delays. Can a governor just let a bill gather dust on their desk forever without making a decision? So one of the central questions asked by the president was whether courts could step in and actually impose a deadline. I mean, the Constitution doesn't give a specific timeline, and that's what was causing bills to get stuck in limbo. Now, the court stressed that governors need to act reasonably and without delay, but they stopped short of setting a hard and fast deadline themselves. So as we start to wrap this up, let's look at the court's final opinion. Because what the court didn't answer is almost as telling as what it did.
This is really interesting. The court showed a lot of judicial discipline here. They were asked about things like their own bench compositions and their broader powers, and they basically said, that's not what this is about. They declined to answer, saying those questions were either irrelevant or just too broad. They kept their focus lasered in on the governor's role.
So if you're going to take one thing away from all of this, let it be this. The governor isn't an outsider to the lawmaking process. They're a part of it. Their job is to be a constitutional check, to foster dialogue, to make sure laws are sound, but their job is not to be a permanent roadblock to the will of the people's elected representatives. And that really leaves us with one final thought. The Supreme Court has now laid out the rulebook with incredible clarity. So the question for all of us is, will this actually change how the game of governance is played out on the ground? Well, I guess only time